today at 9 a.m., the ACLJ filed on behalf of the Heritage Foundation, their client, in the case opposing the Biden vaccine mandate for employers with 100 or more employees. That goes into effect tomorrow, but the briefing at the Supreme Court was due today. The oral argument will be on Friday.
The mandate comes down from the president through OSHA. Is the OSHA, as an agency of the federal government, do they have the authority to put that into practice? And I think that the clear answer to that, although I think it's going to be a very close case, is they don't. The statutory and constitutional issues are significant here, but if you just go with their authority issues, Commerce Clause issues of federalism, state control of these kind of police powers, I think it makes it a very difficult case. Having said that, the one thing that has us all, I think, and we've been doing Supreme Court practice for 40 years, but I think all of us are perplexed is, Harry, there were 8 requests for a stay, including from our client, and none of those were granted.
And the Supreme Court easily could have given an administrative stay, but they refused to do so, at least so far. And so then the query becomes, what is going to happen between January the 7th and January the 10th when compliance apparently is supposed to kick in?
They're not set up to do this. OSHA itself said they can't do it. Joe Biden, the President of the United States, play it for everybody, said they can't do it.
Look, there is no federal solution. This gets solved at a state level.
That's the President of the United States.
It's our opening line of our brief.
Yes, that's what we open with.
There is no federal solution.
And the state level actually may mean it gets solved at the local level because there could be a local situation different than the state situation. But clearly the states have the police power.
The statute only gives the secretary power to address occupational health and safety risk where? At work. And so now OSHA is essentially trying to regulate health and safety risks that may indeed be encountered off-site.
This is a 400-page requirement that has been in legal flux since the beginning. It was stayed until a couple of weeks ago. The stay got lifted, but the Supreme Court then has this emergency session on the issue of whether or not there should be a stay reimposed.
But there's no
this
stay.
Friday. But there is not between now and the Supreme Court decision. You technically have to start complying with this tomorrow. If you're a business owner with 100 or more employees, you have to start complying with this tomorrow. You're not going to get fined on the vaccine side of this until February 9th.
But that
so
doesn't
you
affect
will
compliance.
know from the Supreme Court.
Right.
But that doesn't mean you have to make a good faith effort to comply now.
It will be impossible to be assured that you are making a good faith attempt. I don't believe OSHA knows what a good faith attempt actually looks like, in part because they have never regulated in this particular arena before.
Does anyone have good faith that OSHA is really going to be that easy to work closely with as an employer? How long are you going to be on the phone to try and get someone on at OSHA if you're an employer with 101 employees? You're not Amazon. You're not some gigantic company where maybe it's easier for you to work with the federal government because you're a contractor with the federal government on various things. But if you don't have a direct line into OSHA now, can you imagine the whole time trying to figure out just because you're trying to make a good faith effort?
First, you don't have adequate testing. So there's not the ability for the employee to get tested in a way that would make sense other than maybe missing an entire workday, which then impacts the employer. And you're already having trouble getting employees. So that's number one. Number two, as the employer in our situation, I don't exactly know what we're supposed to do. We're going to make a good faith attempt. So we're going to figure that out this afternoon. But this is the problem. And then three, the Supreme Court may give a decision right away. They may not give a decision right away.
With respect to testing, with respect to the vaccine mandate, or the testing opt-out situation, right, we place the burden on whom? The employees to comply. And they have to do it according to their own expense. And so I think we are in basically uncharted territory. And I think that is because that's what the government prefers. They prefer the ambiguity as opposed to the clarity.
This is complicated for your HR department. Then the testing requirements for the employees that are not vaccinated. So the weekly testing, there's questions about, okay, so if you do like the drive-through testing or a test with a doctor, that's one thing. But what about the at-home test? Does that have to be done in person? every Monday at your office. I mean, so the time, the burden on the employee because they've got to go get the test, and then on the employer because they've got to figure out how to monitor all of this and put it together. So there's a double burden here. Who wants the federal government trying to run this?